Hello everyone, welcome to my channel. My name is Emilio Carpio. I am both a licensed professional teacher and an internationally trained lawyer from the Philippines. If you're preparing for the 2025 NCA Civil Procedure exam, this video will provide you with a comprehensive overview of the key topics, study strategies, and essential issues you need to know to succeed. We will cover the core themes in a focused, professional format, ideal for students looking to organize their revision effectively and understand not just what to study, but how to approach it. Let's begin. 1. Background to the civil dispute resolution process. Begin by grounding yourself in the purpose of civil procedure. This area of law ensures that civil disputes are resolved in a manner that is fair, efficient, and accessible. These objectives, fairness, finality, and access to justice, are not just academic. They often frame how judges apply the rules. 2. Basic institution and processes. Understand the structure of Canada's court system. Trial courts, appellate courts, and specialized forums like small claims courts. Know the procedural rules that govern each stage and the role of judicial discretion in managing cases. 3. Limitations, capacity, standing, and parties. Know the key limitation periods and how to calculate them. Understand who has the capacity to sue or be sued, and how standing is determined, especially in cases involving children, corporations, or public interest claims. 4. General matters, proportionality, commencing proceedings, and pleadings. Start with the rule of proportionality. Procedural steps must be proportionate to the complexity and stakes of the case. Then, review how to commence a proceeding, draft pleadings, and understand amendment rules and procedural timelines. 5. Class proceedings. Focus on the criteria for certification and the procedural advantages and challenges of proceeding as a class. Class actions promote access to justice and judicial efficiency, but they come with unique requirements that must be met before a case proceeds. 6. Jurisdiction and service. Understand how courts determine jurisdiction, including interprovincial and international considerations. Learn the rules for service, both within Ontario and outside, and what happens if service is improper or challenged. 7. Discovery, evidence, and experts. Review the structure and obligations in the discovery process. Know what is discoverable, what is protected by privilege, and the procedural rules around undertakings. Expert evidence must be neutral and follow formal rules regarding disclosure and contempt. 8. Case management, pre-trial conferences, and ADR. Case management ensures that litigation progresses efficiently. Know how pre-trial conferences operate and the role of alternative dispute resolution. Many jurisdictions require or strongly encourage mediation, especially early in the process. 9. Motions and interlocutory relief. Master the procedure for bringing motions and understand when interim or interlocutory relief is available. Common examples include motions for preservation orders or temporary injunctions, which require structured legal tests and evidence. 10. Disposition without full trial. Courts can resolve matters without a full trial through tools like summary judgments or motions to strike pleadings. These options align with the principle of proportionality and help reduce unnecessary trials when there's no genuine issue for trial. 11. trials, applications, references, judgments, appeals. Differentiate between trials and applications. Trials involve oral evidence. Applications are based on written materials. Learn how judgments are issued, how they're enforced, and the grounds and timelines for appealing decisions. 12. Pluralism of participants and processes. Civil procedure increasingly must accommodate diverse participants, including self-represented litigants and those from different cultural and linguistic backgrounds. Courts are adapting through plain language initiatives, interpreter services, and more inclusive practices. 13. Costs and fees. Understand how courts allocate legal costs, especially to the losing party, but not always. Learn about partial versus substantial indemnity and how offers to settle under the rules can affect cost awards significantly. 14. Access to justice. Access to justice is a central theme that intersects with almost every topic. Consider how procedural rules can either help or hinder litigants through complexity, cost, or delay. Be prepared to discuss reforms aimed at simplifying litigation and reducing barriers. 15. Other topics and issues to consider. And finally, here are several important but often underemphasized issues to be aware of. Res judicata and estoppel. This prevents a relitigation of claims or issues already decided. Understand the principles and when they apply. Delay. Courts expect parties to move cases forward. Unreasonable delay can result in dismissal. Dismissal. Know the grounds for administrative dismissal or dismissal for want of prosecution. Default. If a defendant fails to respond, default judgment may be entered, but it can be set aside under specific conditions. Discontinuance. A plaintiff may voluntarily withdraw a claim, but the timing and consequences matter, especially for costs or refiling. Contempt. This arises when a party defies a court order. While rare, it's procedurally serious. Parallel or related proceedings. Learn when courts may stay or consolidate proceedings to avoid duplicative litigation. Remote hearings and virtual courts. These were accelerated by the COVID-19 pandemic and remain a permanent part of civil litigation. Understand the benefits, challenges, and how they affect procedural fairness and access to justice. That concludes our overview of the core topics and key issues for the 2025 NCA Civil Procedure exam. Remember, success in this subject is not about memorizing rules, but about understanding the principles behind them and applying them to real-world scenarios. If you found this helpful, feel free to like, subscribe, or share it with your peers. Thanks for watching, and best of luck in your preparation.